Hi guys, this is Ayantika, your legal faculty here at CLATapult, and in today's video, we are breaking down one of the most significant pieces of legislation to go live in 2025. That is the DPDP Act of 2023 and the recently notified DPDP Rules of 2025. This legal framework in India is long awaited comprehensive answer to the global challenges of data privacy, a topic that combines constitutional law, technology, and governance, making it a guaranteed high priority area for your general knowledge. Before we move into the substance of today's topic, a quick update related to the courses. Our batches for CLAT 2027 and 2028 have already started. If you're looking for the guidance for the exam or to get enrolled, visit our website mentioned on the screen. For personalized guidance, feel free to reach out on the contact number mentioned on the screen. Coming back to today's topic, the DPDP Act was enacted in 2023, but the DPDP rules were notified in November 2025. This brought the law into full effect, detailing the concrete procedures for compliance. The core philosophy of this law is balancing two things: the individual's fundamental right to privacy, established by the landmark Supreme Court judgment in case Puttaswamy, and the need to process data for lawful purpose in India's booming digital economy. The law centers on 7 key principles, including consent, transparency, data minimization, and accountability. The most crucial element of the new rules is consent. Under the DPDP framework, companies referred as the data fiduciaries must now obtain consent from the individuals or data principals in a manner that is free, specified, informed, unconditional, and unambiguous. This means that the long, confusing fine print that most of us click agree to is no longer permissible. Companies must now provide a notice in clear and plain language that states exactly what data is being collected and the specific purpose for which it will be used. Furthermore, the rules establish a concept of consent managers. These are independent entities that will provide a platform for users to manage, review, or withdraw their consent easily, placing control firmly back in the hands of individuals. The law also introduces the concept of significant data fiduciaries. These are entities, typically large-scale tech companies or those dealing with sensitive data, which face higher obligations. For instance, social media platforms or e-commerce giants with a large number of Indian users must now conduct independent audits, carry out impact assessment, and are subject to mandatory data erasure requirements after a certain period. The strict penalty for non-compliance are a major deterrent, with fines for data breaches or failure to notify the regulatory body. The newly established Data Protection Board of India, running into crores of rupees. In conclusion, DPDP rules are more than just a regulatory update. They represent a fundamental shift in India's legal landscape, enshrining digital right as a core component of constitutional life. The law ensures that the entities possessing your data are held accountable, placing a legal burden on them to secure the digital personal data of every Indian citizen. Thank you and see you in the next video.